You're standing in your driveway holding a stack of papers some stranger just handed you, wondering if your whole life is about to crash down. I'm going to tell you exactly what that paper is, what happens next if you pretend it's not there, and the very specific way you shut the whole thing down. What you're holding is a court document, and the clock is already ticking. When a stranger hands you that paperwork, it means you've just been served. Being served just means the court system has formally tracked you down to tell you that someone is suing you. Usually, it's a debt buyer. A debt buyer is a massive corporation that buys old, unpaid bills from credit card companies for pennies on the dollar, and then they sue people for the full original amount. They bought an old account with your name on it, and now they want a judge to force you to pay. The worst thing you can possibly do right now is throw those papers on the kitchen counter and pretend they don't exist. If you ignore this, the debt buyer automatically wins. In the legal world, winning by default because the other guy didn't show up is called a default judgment. A judgment is simply a court order that says you definitely owe this money, and the court gives the debt buyer the legal power to come take it from you. Once they have that judgment, they don't just wait around for you to mail a check, they actively hunt you down. The court can grant something called a bank levy. A levy is a legal freeze where the creditor reaches right into your checking account and literally takes your cash to pay off the debt. You might wake up on a Tuesday morning, swipe your debit card for groceries, and see it declined. You'll log into your bank app and find a zero balance because the debt buyer swept your account clean overnight. But it gets worse. In a lot of states, they can also get a wage garnishment. A wage garnishment is a legal order sent straight to your employer's payroll department. It forces your boss to take a big chunk of money right out of your hard-earned paycheck before you even see it. Now, your boss knows you're dealing with severe financial trouble. Imagine working a grueling 12-hour shift, checking your pay stub, and seeing hundreds of dollars missing. Your employer has absolutely no choice but to obey the court order. And if that's not enough, depending on where you live, a judgment can attach to real estate you own. When a judgment attaches to your property, it acts like a hidden legal mortgage. If you ever try to sell or refinance your house, that debt has to be paid off first from the profits, or the sale completely dies. Ignoring that stack of papers gives them the power to reach into your bank, raid your paycheck, and tie up your home. So, we have to stop the machine. The only way to protect your money, your paycheck, and your property is to step directly into the legal ring and respond. The very first thing you need to look for on those papers is a specific date. You're looking for the deadline to file an answer. An answer is your official, written response to the court, where you deny the debt buyer's claims and tell your side of the story. This deadline is incredibly strict. In a lot of places, you only have 20 or 30 days from the exact moment that stranger handed you the papers. If you miss it by even one single day, you automatically lose the right to fight back, and the default judgment snaps right into place. You have to drop everything else and deal with this immediately. When you file that answer, you're legally telling the judge that you don't agree with the debt buyer. And honestly, this is where the whole situation can completely flip in your favor. Debt buyers buy thousands of old accounts at a time, and their paperwork is notoriously sloppy. They rarely have the original contract you signed, and they almost never have the detailed, itemized records proving exactly how they calculated that massive total they claim you owe. When you file your answer, you force them to actually prove their case. The court system operates on a strict rule called the burden of proof. The burden of proof means the debt buyer has the total legal responsibility to provide absolute, rock-solid evidence that you owe this exact amount to them right now. They can't just print out a vague spreadsheet with your name on it and call it a day. They have to bring the original paperwork, they have to prove the math is perfectly accurate, and they have to prove they have the legal right to collect it. Because you responded and forced them to do the heavy lifting, they very often fail. A judge will look at their messy, incomplete paperwork, see that it doesn't meet the burden of proof, and throw the entire case out of court. The debt buyer walks away with nothing, your bank account stays completely safe, and your paycheck is fully protected. To make this work, you have to use the right words on your answer form. You will see a section where you can legally challenge something called their legal standing. Legal standing is a foundational rule, meaning the person suing you must actually be the proper owner of the debt. Since these accounts get bought and sold by giant corporations dozens of times over the years, you demand that they prove they specifically own your exact account right now. If they can't produce a clear, valid bill of sale with your specific account number and name on it, they don't have legal standing. Case closed. You can also use a rule called the statute of limitations. The statute of limitations is a hard legal time limit on how long a creditor has to sue you for a bad debt. This time limit varies heavily by state, But as an example, in many places, it's somewhere between 3 and 6 years. If your last payment on that credit card was 8 years ago, the debt buyer is completely out of time. If they sue you anyway, and you point out the statute of limitations in your written answer, the judge will immediately dismiss the lawsuit. But, and this is incredibly important, the statute of limitations only protects you if you show up and file your answer. If you stay silent, that time limit defense vanishes and they win automatically. I need to mention that every single detail we just talked about depends heavily on the specific state you live in. The deadline to file your answer, the rules about bank levies, and the exact length of the statute of limitations all change the second you cross state lines. Local court rules are wildly different everywhere. You have to read the papers in your hand, check your local county court's website for the exact rules in your area, and understand the specific timeline you're dealing with. There will come a point where you need to get a lawyer. If the amount of money they claim you owe is large enough to wipe out your bank account, or if the paperwork is incredibly confusing and you can't make sense of the deadlines, it's time to call in professional help. Many consumer protection attorneys offer a totally free first consultation to look at your situation. A legal professional can tell you in 5 minutes if you have a rock-solid defense, or if you need someone to stand in front of the judge for you. If the debt buyer has already crossed the line and started garnishing your wages, a lawyer can sometimes file a motion to vacate a judgment. A motion to vacate is a formal request asking the judge to cancel a default judgment that was already entered against you, usually because you were never properly handed the papers or you had a legally valid excuse for missing the deadline. This is complex legal maneuvering, and it's exactly when you need someone who knows the local court system inside and out. The main takeaway for tonight is that you have immense power the second you put your foot down and file your response. Debt buyers rely completely on you being too scared, too busy, or too tired to deal with a lawsuit. They want a fast, cheap, automatic win. The moment you file an answer, you make yourself an expensive, difficult target. You cost them time, you cost them lawyer fees, and you force them to work incredibly hard for a debt they probably can't even prove. Taking action shifts the entire dynamic. You go from being an easy target to a brick wall. You force a massive corporation to play by the strict rules of the court system, and you hold their feet to the fire of the burden of proof. It takes a little bit of courage, a little bit of late-night reading, and a lot of standing your ground, but you have the tools right now to make sure they don't just walk away with your money. What single biggest question is stressing you out the most about these court papers right now? Drop that exact question in the comments below so I can read it and address it. If this breakdown helped clear the panic and made sense of the paperwork in your hands, please hit the like button right now. Share this video with anyone you know who might be up late stressing over a debt lawsuit. And make sure you subscribe to the channel right now so you always have a clear, honest guide for navigating the legal system. This video is strictly for education. It isn't legal advice for your specific case. Laws are different everywhere and change constantly. You need to consult a licensed attorney in your state for guidance on your actual situation.